Hello, and welcome to this presentation of Assisted Reproduction Agreements. The most common type of assisted reproduction agreements are egg or sperm donor agreements, embryo donor agreements, and surrogacy or gestational carrier agreements. First, some common terms. The intended parent or recipient is the person or couple who intend to parent the resulting child. The donor is the individual or couple who is donating eggs, sperm, or embryos. People might be surprised to hear that the donor's spouse will be named in the agreement and sign it too. Sometimes a life partner is included. Surrogates can also be called gestational or compassionate carriers. ART refers to assisted reproductive technology such as IUI and IVF. Let's start with the most straightforward ones, egg donor agreements and sperm donor agreements, which are fairly similar. If the recipients are using an egg or sperm bank, they will usually have a standard agreement from an anonymous donor who generally waives all rights. There usually isn't a lot of negotiation, but it is helpful to have an attorney review this. When the recipients are having a friend or family member donate, attorneys are more commonly involved and there is more customization available. Some agreements are a blend of the two. The donor is someone unknown previously, but one or both parties wants more customization in their agreement. Embryo donor agreements are drafted when the recipients have extra embryos they want to donate further. When this happens, the recipients now become the donors, and the proposed new owners of the embryos now wear the recipient hat. It is important to verify that the donors have the right to donate the embryos further. If they are the genetic contributors, this is clear. However, if they use donor sperm, for example, it should be verified that the sperm donor agreed that the embryos may be donated to third parties rather than be destroyed, for example. Now, let's say that the new recipients don't use all of those embryos. Sometimes the embryo agreement includes a reversion agreement where they are returned back to the donors and they become the recipients again. There can be multiple layers of owners and previous owners when a pool of embryos are shared, redonated, and returned. Surrogacy agreements are the most complex of all ART agreements. They involve the widest scope of time and the most potential health and financial considerations. There may be more detail on what is paid, and discussions of insurance should be included. As a result, these agreements tend to be more time-consuming and therefore include more legal expense. The surrogacy agreement is a private contract. However, it is common to follow up a surrogacy agreement with a court action to confirm parentage. The most important provisions in any ART agreement include confirmation that the recipients are the parents and have full financial and legal authority and responsibility, confirmation that the donor is not the parent, who can direct and what may be done with the excess materials such as donation, disposal, or redonation to third parties, compliance with state law, in addition to many other provisions. What is the process and how long does it take? Typically, the recipient gets the ball rolling by retaining an attorney. Next, the other party retains a separate attorney. They cannot share the same attorney as a measure of procedural fairness. The recipient almost always pays for both attorneys, although sometimes the donors volunteer to pay for their own if they are close friends or family. The recipient's attorney usually prepares the first draft. The other party reviews it with their attorney. Drafts are finalized, signed, and notarized. Sometimes the clinic requires a legal memo, which is sort of like a Cliff's Note version of the agreement, and sometimes a court procedure follows. Please do not use a form from the internet. I've seen these and they omit very important information. They are also not customized to reflect the law of your particular jurisdiction. This is state-based law, so you can't take a form from Alabama, for example, or created from AI from all of the information of the internet and assume it's going to work in Washington state. Also, look at the attorney's website and see if they practice in this specific area of law, which is ART or reproductive agreements, and not just generically say family law, which generally means divorces in Washington state at least. Well, that's a short overview of assisted reproduction agreements in Washington state. As per usual, consult with an attorney in your jurisdiction for advice specific to your situation. Let us know if we can help, and thank you for watching.